I find far too often that I have clients that come to me after the fact and say, hey, we don't have a contract. So having a contract is super important. And Jessica will talk more about, the execution of the contract and things like that. But we have to start with the contract. But the contract also has to be appropriate to the project, not only for insurance, but for all reasons. But we're talking about insurance today, right? So having a contract that doesn't have the appropriate insurance requirements in it is not going to help you. And those insurance requirements and the insurance itself for the project has to be specific for the project, right? And when we say project specific, that doesn't necessarily mean a project specific policy, but just that it is the right insurance for the project, that it is commensurate with the work that's being done and with the risk transfer, which Jessica is going to talk about, that you want to achieve. So one size does not fit all. You want to make sure that the construction that you have, the insurance that you have for your project does tie in, with the work and also with the insurance program for the project. Sometimes there may be an owner who's buying insurance for everybody. Sometimes the contractor may be buying the insurance for the subs. You want to make sure that that's properly reflected in your contracts. Because if it's not, then and the two don't match, you might have problems in the claim process down the road. And one of the takeaways I want, and I think we all three of us here want to share with you, is that you want to make sure that the insurance is correct before the work starts. You don't want to find out about something later. So the insurance requirements need to be specifically stated in the contract. This is just some general language that comes from, contracts, AIA forms, things like that. And these are just, of course, random types of policies as well as limits. But what's important is that they be included in the contract, that the actual insurance that's required is stated as a requirement of the contract. Many times I have clients that just, will leave the entire insurance section blank, and they simply will just say, see Exhibit A, and then Exhibit A will have a certificate of insurance attached to it. That's really not sufficient. And we're going to talk about why the certificate itself isn't sufficient. But in terms of the contract, that's really not sufficient. Because first of all, as we know, those of you who may be attorneys on the call, or, even your owner, your contractor, whoever you may be, sometimes exhibits don't get attached. They get lost. The agreement doesn't get put together and compiled properly. You don't want to just be referring to a separate document. It's fine to attach the insurance to the contract, but you want the insurance requirements expressly stated in the contract so that everyone is clear that this is a contractual requirement. So that's very important. And again, having the proper insurance listed is what's important. I mean, here on this particular slide, we have professional liability. Now we've added, if design build. Sometimes forms don't always say that, right? And someone will have, professional liability in there, and it may not be, correct for the project. Now, if it's left blank, that's fine, but what we don't want is to not have something in here that should be.
I'm even seeing cyber now being included in contracts occasionally, considering, the current climate that we're in and how contractors are, being poached. I'm seeing that.
Yeah, the valuable papers, which used to be, part of a lot, now it's a lot of cyber, and, people don't have papers anymore. So, but yeah, so this is certainly not an exhaustive list of insurance that should be included. So I want to talk, before we get into the certificates themselves, or I want to talk about just a little bit, are really two things here under this umbrella of master service agreements. So there's master service agreements, and then there's also these sort of master form agreements that I a lot of times have my clients ask me to sign. So let's start with master form agreements. People don't like to spend money on attorneys. They just don't. And a lot of times my clients will come to me and they say, okay, we need a contract. We're owners and we need a contractor for, a general contractor or trade contractor, or they're general contractors and they want an agreement for a subcontract. And while I oblige reluctantly. And I try to stress to my clients that you can't really stop there, and not every project is going to be the same, as I've already said. And the requirements of a specific sub or specific GC may not always be the same. So I'm always a little hesitant about having this one size fits all agreement, because one size does not fit all. And that doesn't necessarily mean that, a big project or a small project. It's the scope of the work. It's so many different things that go into it, what your loan requirements may be, what you as the owner's insurance requirements may be that you need to pass on, which we're going to talk more about. So having this idea of having a master form agreement is not always a great idea. I do stress to my clients, just run it by me, let me know when you're using it, so I can also make sure that it's the right agreement. Because a lot of times what'll happen is I find out after the fact there's now a problem, and they send me what was essentially a contract that was appropriate either for a design professional or a contract that I drafted for them that was for a simple one-off job, like fixing the boiler in a building, and they're using it for a major building renovation. So we do want to be careful about that. And then master service agreements, which you may have come across, is a little bit of a different form. And what that generally is you have someone that is, say you have a sort of a handyman or a maintenance type contract with a certain company, and they're going to come in and they're going to kind of do a lot of different fixing and things in the building. And maybe you have a host of buildings, so you have this master service agreement that sets for basically the general legal terms between the parties, and that should set forth insurance and indemnity. And then you issue a purchase order or an invoice or a service order for each individual job that they're going to do. And that may be on a different building. So the insurance needs to match. So when you add these extra purchase orders or service requests, they may not contain the right insurance and list of additional insureds and all of those things, because they're not captured in the master agreement. Yeah. And then people forget to put them in the other agreement.
So Michael just shared that his company has a master service agreement, which they use for their NYCHA projects, because there's so many different buildings with different work orders.
Right. And look, and again, I'm not saying that they can never be used. I'm just saying be wary of them. Because, for instance, if you're doing it on another building, then you want to make sure that all the right, there might be some other additional insureds that need to be added for a particular building, or the nature of the work may be a little different. So, all we're saying here is just make sure, don't get sort of lazy or complacent with the fact that you have this master agreement and think that it's going to always be the right agreement or an all-encompassing agreement every time. And we're going through things really fast here, so we don't have a ton of time, and I want to get to my colleagues as well. But so just in general, and I'm going to let Jessica talk a little bit more about this, but everyone on the project needs insurance. And I know a lot of times when I'm representing owners, they say, I don't really need to worry about the subcontractor's insurance. My contract is with the general contractor. And that's not true. And the relationship between you and the general contractor and the general contractor with their subcontractors is important. And to make sure that the risk is being borne by the proper party. And insurance and the contracts tie all of that together. I'm going to pause on that issue. I'll let Jessica talk more about it. So I want to get to some of sort of the things that actually, as Jessica mentioned, made this all come about, right? The horror stories, the things that, we've seen and how to avoid them, right? So we want to always be reviewing the insurance on all contracts. I've said that and I know that it can be time consuming, and we're going to talk about how that can be, managed and compliance and all of that. But what's the important takeaway here is you don't want to wait until the claim has been filed, because then it's too late. Because if you find out at that point that the occurrence has already occurred, you may not have coverage for that. And people will say, but that can't be right. I got a certificate of insurance. When we signed the contract, I got a certificate of insurance from my contractor, and it had lots of millions of dollars of different types of insurance on it. So I'm fine. Well, you're not necessarily fine. So let's just talk really briefly about the certificate of insurance. And this is just a blank Accord form, the Accord 25. And it does have a lot of information on it, but it doesn't have all of it. So it's going to tell you, obviously, who the insured party is. And you want to make sure one important thing for your contracts, you do your contract with a contractor, right? And then you get the certificate of insurance and the name's not the same. You want the insured on the certificate of insurance to be the party that you're contracting with. I mean, it could be a DBA or something like that, but you want to make sure. More often than not, I get a certificate, from a broker, and either the name's just off by a little, it's an LLC versus an Inc. or Corp or something like that. But sometimes it's a different company altogether, and either they've sent me the wrong insurance, obviously, or it's that, this contractor has two different, companies. Maybe one's a union shop and one's a non-union, or one does facade work and one does something else. You want to make sure that the insurance that you're getting is for the person that you're contracting with. So that's very important. So we want to make sure that insured is correct. And here again, there's a lot of information. We're not going to go over in detail because we don't have time, but yes, it's going to tell you who's issuing the policies, that list of the insurers affording coverage. It's going to, it's going to correspond to each of these different types of insurance. It's going to tell you the policy number. It's going to tell you the dates of expiration, obviously important stuff, and it's going to tell you the limits, right? And so a lot of people just stop there, and that's not the place for you to stop, because what you don't know is what's not on here. And what's important about that is knowing that the certificate of insurance is just the tip of the iceberg. And I love this slide, and I use this phrase a lot because it really, really is important, because that certificate of insurance doesn't tell you what's actually covered by the policy. And so I want to go through quickly a couple of the issues that I've had and how you can avoid it. So you want to look at the forms and endorsements of the actual policy and the policy itself. But what I do as an attorney, I'm not an insurance, professional, but more often than not, my clients are relying on me to some extent to vet the insurance. And so I do want to make sure that I'm taking at least the minimal steps, or at least I can point out to them, hey, I'm not comfortable with this, or we need more information, and you need to talk to your broker. You need to talk to your risk manager. We need more information. And the place to start is these forms and endorsements. So sometimes I say, just give me the list of the forms and endorsements. And what that is, and this is an endorsement itself, but what each policy has is a declaration page. It's going to have the list of all the forms and endorsements that are included in that policy, what that $1 million actually covers, right? And a lot of it's basic stuff and it's standard stuff, but then there's a lot of endorsements which actually act as exclusions to the coverage. And that's really where it can get a little dicey. So let's talk about some of the exclusions that you have to watch out for. And just to go back, when you see that list, right, it's not going to if you're not getting the whole policy initially, it may be enough to start there and then see if there is an endorsement that gives you a concern, right, based upon the work that is being done. And here's a perfect one, a height limitation, right? And this is something that happened to me many years ago, and I was representing an owner who was demolishing a building in order to make way for their future construction project. And as some of you may know, a lot of times when you're doing demolition, there's not a construction policy in place yet, right? Because you're not in construction, you're still in demolition. So many times an owner just has their own basic property protection, and you're relying on your demolition contractor's insurance to be the insurance that is going to provide your commercial general liability coverage, the coverage that's going to protect someone from being injured from the work, or from there being some property damage to other properties as a result of the work. So in this particular instance, my client was on the verge of having the demo done. We had a contract. I kept asking for the insurance over and over. The day before the demolition was supposed to start, I finally get just a certificate of insurance. My client says, okay, we're all set. And I said, well, wait a minute. And I said, I really want to see the forms and endorsements, because I had noticed that one of the carriers is one to be known to have some exclusions to policies that they typically issue policies with exclusions. Unfortunately, I saw, this contractor, this insurer on the form. So I said, I really need to see the list. Everyone hates me. Everyone's mad at me. Everyone thinks I'm going to hold up
This
the
happens
demolition.
all the time, and they fight back. Owners fight back on the recommendations when you find these limitations. Oh, but I've had that policy for 10 years. Nobody's ever said anything, is basically what I hear.
Yeah. Well, and I think it's twofold. I think it's sometimes the contractors don't even know what's in their own insurance, or sometimes they do, and they're just feigning ignorance, right? But in this particular case, we were doing the demolition of a 110-foot building, and there was a height exclusion that I saw on the list of forms and endorsements. So I said, I need to see this height exclusion. Well, sure enough, this contractor had an exclusion for buildings over 100 feet. So that means that and let's be clear about what the exclusion means. It means there's no coverage for the entire project. My client actually said to me, true story, and I won't obviously tell you who this was, said, well, if we're able to lop off the first, the top 10 feet of the building and we're down to 100 and the occurrence happens later, are we okay? And it's not an illogical question to ask, but the answer is no, you're not okay. Because the entire project that the demolition contractor is doing is the demolition of a 110-foot building. And in that instance, you would have no coverage should someone be injured when they're, down to the second floor. So a height exclusion is very important while you're doing demolition. If you're doing, any type of facade or exterior work or roof work on a building that is of a certain height, and the contractor has an exclusion in their policy.
This would be a good segue for you to just show them the different slides with the different limitations so that these are some of the common ones, because we want to make sure we keep with the time.
So I want to focus on two more. Cross suits exclusion. Again, horror story. I represented general contractor. Owner and general contractor have a joint policy, so they are both named insureds under the policy. But there is a cross suits exclusion. So you cannot sue each other, right? So if you sue each other, you actually wipe out the insurance in simplest terms. And in this instance, a third party's property was damaged by the construction. The third party sued the owner, the developer, and the owner developer then in turn sued the general contractor for those damages, and it wiped out the insurance. I called the plaintiff's counsel and I begged them, I said, you need to drop this suit against us because you're wiping out the insurance, because there was this cross suits exclusion in there. So you can't, the two named insureds cannot sue. They can sue each other, but there's no insurance coverage if they sue each other for an otherwise covered occurrence. And one more action over, any of you who are especially practicing in New York or working in New York, you know that our Labor Law 240 is of particular importance, but action over applies everywhere. And action over, it very simply is that there's an exclusion in the policy for employees who are injured. So in the scenario is that I'm an owner, I hire a general contractor, I have insurance, everything's fine. But the general contractor has an action over exclusion that basically says that if employees of either the general contractor or sometimes their subcontractors as well are injured, there's no coverage for that. So what happens? Subcontractor employee gets hurt on the job, right? They have their workers' comp remedies against their employer, but they end up suing my client, the owner, or the GC. But they usually, they'll sue the owner of the property. And I would then look to my indemnity in my agreement from my general contractor. But if there's this action over exclusion, there's no coverage for that injury. So regardless of my indemnity, I can still try to enforce an indemnity, but we all want insurance to be available. So with that exclusion, then you're losing that ability to have that insurance coverage, and then it's just a straight, claim that's not covered by insurance. So I know that was a lot.
And by the way, you're not going to have, obviously as an owner or developer, you're going to have a lot more exposure. So hopefully your brokers are going to be covering you for here. Where we really see the issue with action over is with the trades and the sub trades. especially if you're operating in the MBE space, MWBE space, no matter where you are in New York, if you're looking for those types of subs, you know, a lot of them do not have the coverage because it's just so expensive. And so this is definitely something that, believe it or not, a lot of people don't know either.